Hey, good afternoon, everyone. Good afternoon, good evening, good morning from whichever part of the world you are joining. My name is Vaidi Iyer. I'm the ex-chief of operations of IBM Security Command Center, currently the strategic advisor to Raksha Technologies. And hearty welcome to you on this webinar, which is where we have some very interesting topic of discussion. As your chosen security partner, Raksha Technologies, we come with 360-degree security solutions to you. And it is our continuing endeavor to bring the latest by way of products, technologies, services, skills, and knowledge to our client partners. As part of that exercise, we are delighted to partner with the leading enterprise digital rights management solution, data security software organization, Seclor, who has cutting edge technologies, who are a leader in the information rights management solution, data privacy solutions here. And we have the founder CEO, Vishal Gupta, here with us. And also we bring Dr. Pavan Dugal, who is I would say, the expert in the cyber law space, a legal eagle, a practicing advocate in the Supreme Court of India, runs his own organization, and a person whom most of the country goes to in case of cyber law legal requirements. The topic of the webinar today is moving from infra security to data-centric privacy. Now, are these different? Actually not. They are very much connected. The technologies that we use today help us to manage security, help us to manage security as an enabler of business. And as we move into the world of decentralized identity, the security as an enabler, privacy and regulations play a major part. Now, these are also, the laws are also enablers for helping our business as we evolve in doing business. We need to follow the laws, and we need to use our current technologies and solutions which are available to suit the new laws which are coming up within the legal framework. So this is going to be an interesting discussion. I'm going to hand it over to the founder CEO of Seclor, Vishal, to take it from here and then pass it on. So once more, hearty welcome to all of you, and hope you will enjoy the session with Vishal and Pavan Dugal. Thank you very much.
Thank you, Vaidi. Thanks a lot for having me, and always good to be on the same panel as Pavan. It elevates my profile also. I think the topic is very relevant, and I just wanted to speak about the evolution of privacy and security and privacy regulation in India a little bit, right? And I might be dating myself here, but I still remember maybe about 20 years ago, regulators like RBI and IRDA and so on, they used to come up with what I call system level controls that need to be implemented. So I remember many notices from RBI where RBI had mandated all the banks that you should have hardened your computers, you should have deployed a DLP system, you should have deployed a firewall system, and it should have appropriate controls and so on. So if we look at and other regulators were not very far behind. So if we look at where we have come in from those days to the DPDPA becoming an act from being a bill for many, many years, actually decades, I think the fundamental change that I see is that earlier there were controls being implemented or being enforced on infrastructure. So what I mean by infrastructure is the combination of devices, networks, applications, and so on. And all the regulators were going in and saying, hey, your infrastructure need to be secured, your processes need to be in place, and so on. Right. So it was as I look at it, it was a very effort-based regulation, which means that as long as an enterprise can prove that they had all the systems and process level controls and so on, they were fine, irrespective of the outcome. Even if the enterprise had a breach, as long as they could say that there were appropriate controls in place when the breach happened, it was still fine. What I call a very effort based, right? As long as you make the right efforts, God will take care of you kind of situation, to the DPDP Act, where none of these infrastructure level controls matter now. So it doesn't matter how secure your devices are, or your networks are, or your applications are, and how many security awareness trainings you do, and so on. The outcome, the ultimate outcome, that citizen data or data in general, personally identifiable data, needs to be protected, is a very outcome oriented regulation, right? I don't, as a regulator, I don't care what controls you have in place, as long as you achieve this end result that is incorporated in the act. So I think in the last 20 years, that's one change that has happened, which is regulations in general, privacy and security regulations have moved from being infrastructure centric, devices and networks and so on, to being data centric, which is the real asset that any enterprise wants to protect. And the second thing here is that it has become from effort based, commercially reasonable efforts were taken, right? That kind of language, to results based, which is, hey, it doesn't matter what is the effort, how old is the company, how new is the company, and so on, as long as the end result is achieved. And I think the third thing, which is different about regulations, were largely coming out as notices from the respective industry regulator. Again, RBI, IRDA, the Telecom Regulatory Authority, and so on. And therefore, they had very little teeth. The number of enterprises who were ever pursued, or legal action was taken against enterprises in breach of the IT Act, or which has now become elements of that have become now DPDPA. There was no real action. I mean, I don't know of too many lawsuits in this space, because the law or these notices or advisories didn't have any teeth. Right? What happens if you don't follow the law was still not very certain, the path were not very defined, and so on. Fast forward to 2023, now a combination of the DPDPA and along with a couple of other other regulations that Pawan, I'm sure, is going to cover, could land up key personnel in the company, in prison. Right now, that's a lot of incentive for people to make sure that the regulations are followed and compliance is achieved, and so on. Right, that's a big incentive. So I think those are some of the key changes. Right, infrastructure centric to data centric is the key move over here. And in the end, secure infrastructure doesn't really mean secure data. It is necessary but not sufficient, right? And with that context, I'll pass it on to Pawan. We'll make it interactive towards the end, guys. Questions and so on, we'll open it up for the audience. But there's no better authority to speak on this topic than Pawan. So it's a pleasure, Pawan. Thanks a lot, and over to you.
Thank you, Vishal, for those kind words. Hi, everyone. I have a small presentation, so maybe a good thing will be, let me get started with sharing my presentation with all of you. So it's a different ball game that we're currently working on. And companies need to get out of their deep slumber. Why do I say that? I say that because for a variety of purposes. Let me first look at the figures. But 80% of Indian companies have already been hit by a ransomware attack. That's this is report. Then in 2023 first half, we have actually seen that ransomware cyber attacks have surged over twofolds only in 6 months. Figures tell us that India is becoming an increasing target of cybersecurity breaches, and this is a report from one of the vendors. But the average cost of data breach in India reaches 17.9 crore rupees in 2023. No wonder India has emerged as the top 3 targets who are targeted by cyber attacks as per this report. So in this ecosystem, where do we stand? Data is the new oil of the data economy, and the world is generating huge volumes of data. So in this context, companies are also generating huge volumes of data, and they have to ensure compliance with various provisions of law in order to limit their exposures. I want to highlight 3 thrust areas for companies to focus on in today's ecosystem. First, the Digital Personal Data Protection Act 2023. Second, the IT Directions 2022. And third, the Information Technology Act 2000 and the IT Rules 2021. These are your 3 main thrust areas for organizations if you want to be in safe waters. First and foremost, the Digital Personal Data Protection Act. This has now become law with effect from 11th of August 2023. Basically, it's focusing on giving notice to data principals that we would want to go ahead and process and collect your data. We would be collecting and processing your data for this particular purposes. And if you have any objection, you can actually file an appeal to the Data Protection Board. Once the data principal is giving you his consent to process his data, collect his data, then you as a data fiduciary can go ahead and process the said data. But non-compliance of this law is going to be very expensive. Why? Because they have actually stipulated a fine of 250 crore rupees per contravention for non-compliance. So assuming your company does 4 compliances, you have to be just prepared for 1,000 crore rupees fine. Now, this is a huge amount of money that's going to put a large number of companies out of operation. In addition, if you are found to be in violation of the DPDP Act, it's going to cause huge reputational risk to organizations. The fines that will be levied on you will not go to any individual, but will go to the government under the Consolidated Fund of India. And once you don't pay, the government has the power to go ahead and get the said fines out of you by going ahead and attaching and selling your properties and assets as well. That's the first thing I want you to be prepared. The second option and the second focus area that I want companies to be prepared is this IT Directions 2022, which have come into effect from 28th of June 2022. In a nutshell, they are telling us that if any organization or any other legal entity comes to know of a cybersecurity breach on its network or on its systems or computer resources, then it has to mandatorily report this within 6 hours to the Indian Nodal Agency on Cybersecurity, being the Computer Emergency Response Team of India. You don't report, at the end of 6 hours, you automatically commit an offense under Section 70B of the Information Technology Act 2000, punishable with imprisonment and fine. And this reporting will have to be done to the nodal agency only, which is CERTIN or the Computer Emergency Response Team of India. The problem is, if you think that this law is not in action, think again. A lot of our clients and companies have begun to start getting notices from the requisite agency saying, hey guys, we've come to know that there's been a breach on your system, but you have not reported it. Would you like to show cause while action should not be taken against you? So, nutshell, the issue is you don't comply and a file gets created about you in the government. And the folklore says once a file is created in the government, it's going to take a long, long time before the file gets finally stopped. So these have to be also supplemented by various other compliances that you are required to be doing under the IT directions. And this has huge criminal ramifications for the top management of the company. The IT Act says if a company commits an offense, the top management is deemed to have committed the said offense. So since the company can't be sent to jail, all the board members, all the CXO level people can definitely be sent to jail, whether you are a CIO or a CISO. So that's the second big thing that I want you to look at. Please go ahead and minimize your exposure to criminal liability under the IT Directions 2022. The third thing I want to understand is that every company in India becomes an intermediary under Section 21W of the Information Technology Act 2000. As an intermediary, you are now required to exercise due diligence while you discharge your obligations under the norm. So you are required to comply with the IT Act. You are required to comply with the IT rules, including the IT rules 2021, which have come into effect from 25th of February 2021. You can say, well, I don't comply. No problem. Just tighten your belts. Why? Because the law says you don't comply, you lose your statutory exemption from legal liability that the law grants you as an intermediary. Number two, your top management can be both booked and the company can be booked for civil liability of unlimited damages by way of compensation and also of criminal liability of imprisonment and fine. So you can also be booked for various offenses under the IT Act and the Penal Code. Why do I say this? Because Rule 7 of the IT Rules 2021 says this. It says where an intermediary fails to observe these rules, the provisions of subsection 2 of section 79 of IT Act will not be applicable. That is, no statutory exemption from legal liability, and you will be liable to be punished under any law for the time being in force, including the IT Act and the Indian Penal Code. So therefore, compliances have to be the only mantra for companies going forward. Companies and their respective CXO level officers, including CIOs, CISOs, and CROs, need to ensure compliance to potentially save the company from potential civil and criminal legal liability. Hence, please focus on these three things: compliances with the Digital Personal Data Protection Act 2023, your cybersecurity compliances under the IT Directions 2022, there's a typo there, and of course the compliances under the IT Act and the rules and regulations made thereunder. The bottom line is very clear. I can't predict when are you going to be attacked next, but there's almost absolute certainty that you will be attacked. So therefore, due diligence, caution, and care will have to be your only mantra as you go forward, and there's a need for more capacity building. My law firm, Pavandugal Associates, actually is offering $0 contracts for the DPDP Act and the ICERT rules. We provide external expert advice on all perspectives and help companies to protect themselves from potential legal exposure. And I think organizations will be very well served if they look at various tools and services from various vendors, which will help them to ensure compliance with the applicable laws. We will need to adopt cybersecurity as a way of life and inculcate it as part of our corporate culture. This is the only way as we can go forward, because at the end of the day, when there is a legal exposure, they want to look at your documents. Nobody is going to listen to your verbal testimony. Therefore, again, written due diligence, caution and care and compliance will have to be a mantra. My law firm, which works on the intersection of law and technology, sees every day as a new day, because every day we keep on learning something new, and this is what others talk about us. But from the perspective of the DPDP Act, we offer these three colored services. The DPDP Red, which is minimal compliances under the DPDP Act. We offer the DPDP Orange, which is more compliances than the red one. But the DPDP Green one gives you complete compliances for your complete legal safety as we go forward. And finally, we also run a platform called cyberlawuniversity.com. I run about 37 courses online. These courses have been done by 29,500 professionals from 172 countries, speaking 52 national languages. We'll end up doing a big international conference, the International Conference on Cyber Law, Cybercrime, and Cybersecurity, 29th, 30th November, 1st December. Rise of emerging technologies and AI and their impact, including AI, is the focus this year. 160 organizations globally are supporting this conference and would be delighted to welcome all of you for that. With that, over to you, Vishal.
Thanks a lot, Pawan. Really helpful. As I heard one of my friends recently say that if you think compliance is expensive, try non-compliance, once, and then you can compare the costs and so on. But I think there is one interesting, even etymological change, which is that regulations had different names. And nowadays, the more recent regulations that have come have always a D in them, right? GDPR, PDPA, DPDP in India, and so on. So at least the regulators themselves are moving towards taking an outcome-based approach to regulations. I wanted to talk about just a quick question from myself before we open it up to the audience. One is complying itself, right? Which is by itself a challenge. But then there's also proving compliance, right? And sometimes the second is even a bigger challenge than the first one. Do you have advice, suggestions on how do we prove compliance? How does any enterprise prove that it is actually compliant with this, that the data breach didn't happen, or whatever was the outcome, desired outcome?
Ours is a evidence-based or proven-based justice system where everything has to be proved. So if you say that you are compliant, the law is going to ask you, show me your documents, your written policies, your written compliances. You don't have that, the law does not believe you. Similarly, in the event of a cybersecurity breach, if somebody in your system sends you an email or a WhatsApp or any other message which is documented, that's the starting point for that 6-hour time frame to get started. And you may want to go ahead and delete that. But if you delete electronic evidence, you engage in forgery, which gets you 7 years jail time and fine. So we never actually go ahead and encourage our clients to look at that. Have your documented written compliances, your written policies. Even if you're deficient in fully implementing the policies, that's stage 2. But if the law prima facie finds that I have given you, for example, under the IT Act, 36 parameters to comply, and you don't have those 36 written documentation, then the law prima facie presumes that you are non-compliant. And if you're non-compliant, then automatically you become as an accused. So the bottom line is, first get our documentation in place, have our processes in place, get effective tools so that you can tomorrow be able to show through electronic evidence that this is how I'm complying with the law.
Got it. No, this is super helpful. Thanks a lot, Pawan. Vaidi, do you want to just open it up to the audience?
Thanks, Vishal. Thanks, Pawan. That was very, very enlightening. A little scary as well for all of us. The participants here, thank you very much, and we are open for questions. You can actually put the questions in the chat window, and please understand we will try to reach at every questions. All questions will be monitored, because all of us are new to this concept, and we have the experts here. We have Pawan here. We have the data security expert Vishal here. So let's open out and come out with questions. And all questions are equally important to us. So please shoot your questions now. We will wait for that, and we will open up for questions.
All right. And while we wait for audience questions, I think one of the things that in our journey as being a data-centric security company, we've realized is that on the very last point that we were talking about, Pawan and I, that proving compliance has also gone to becoming data-centric. So instead of tracking logs on devices and network traffic and those kind of things, regulators have already in other countries, and I'm sure in India, the effect will come pretty soon. The regulators themselves want proof at the data level, right? That, hey, tell me everything that has happened to this piece of data is more the question nowadays than show me all your system controls, and process controls, right? And so we've seen some of the largest reasons to deploy data-centric security and data-centric privacy technologies is that these kind of technologies provide visibility at the data level rather than at the infrastructure level, right? And so on. Vaidya and I think the Secure team, there are a couple of people who've raised their hands on asking questions. I don't know.
There are some questions already, Vishal.
Oh, okay,
there are already some questions, and Pawan, I will have a question for you once these questions are answered as well. I wanted to come. So, is anybody reading out, or I can read out the questions here. So this is from Mr. Chudamani. Who or what are consent managers? I think that question is for Pawan. If you can put the question, and if you want to direct the question to any particular panelist, you are welcome to do so. Since this question is more legal, I would assume it is Dr. Pawan who would answer this. Who and what are consent managers? It's there on the chat window, Pawan.
Well, the DPDP Act has come up with various statutory creatures. One of such statutory creature is a consent manager. Consent manager is going to be a person who's going to be appointed by a data fiduciary. Any company who's dealing with personal data of others becomes a data fiduciary. Now, for the first time under this law, data principals have been given a lot of powers, including the power to say yes to processing and also the power to say no to processing. sometimes they may often require assistance as to whether they should say yes or not. So in order to help answer those questions, every data fiduciary is required to have a consent manager whose only job is to help the person who's holding the data or the data principal to help understand whether he should give his consent or not and how he should give his consent. Now, this has to be a person-driven exercise and not an automated exercise, because the law is expecting a consent manager to be human-based. And therefore, you will have to put your one person dedicatedly as a consent manager. And lo and behold, if somebody of your data principal reaches out to him, then his only job is to help the data principal come to the correct decision as to whether he should give his consent or not. Also, once a data principal gives the consent to a company, being a data fiduciary, that you can go ahead and process my information, and tomorrow he changes his mind and he wants to withdraw his consent, then the consent manager is further going to help the said data principal to withdraw the said consent. Similarly, if the said data principal wants some changes or corrections in his data, he can also approach the consent manager, and the consent manager can then help the said data principal to go ahead and make appropriate changes or corrections in his data. But in a nutshell, as the name says, consent manager is all about assisting the data principals pertaining to how they have to give, not give, or withdraw or change their consent pertaining to processing of the data by the company being the data fiduciary. Thanks.
I have a lot of questions. So, Devesh, if we can help getting these questions and probably the emails, then we can respond, because I don't think we'll be able to reach to all questions. But I will just come back and pick up some questions here. I think, again, this is primarily all the questions are coming into Pawan. Is DPDP training certification related, and is it a company end action, or is it to be individual or company? This is by a gentleman by name Kulashekaran. So we have picked up that question.
The DPDP Act applies to various entities, including individuals, including companies, corporations, and governmental agencies. So at the end of the day, in case if you are collecting the personal data of another person, then you are required to ensure compliance with this act. Of course, the law says if you're only collecting it for domestic purposes, then you are not required to ensure compliance with the DPDP Act. But primarily, in a case if you're working for a company, the company becomes the data fiduciary who determines how the personal data of a data principal is going to be processed. So the company definitely has to ensure compliance. Similarly, the certification is all going to be focused on how have you gone ahead and implemented the requisite procedures and practices that are going to be stipulated by the DPDP Act and rules and regulations. But if you as an individual, you are also collecting third-party data, which has got no connection to the company, then please realize you also become a data fiduciary. And that being so, you will also be required to ensure compliance. But I think the focus will have to be more on creating capacities. Most of the people still are not much aware of the nuances pertaining to the DPDP Act. And this can be pretty disastrous, because one fine of 250 crore rupees is enough to put a large number of companies out of operation. Thanks.
Absolutely. So, Pawan, very interesting question now. I mean, this is about health sector, so I just picked it up. It's from Surya. He's asking about implications of data protection. What are the implications of Data Protection Act on a hospital, especially when it comes to admitting minor patients? Especially, what are the scenarios in which consent becomes mandatory for minor patients and patients with disabilities who probably may not be, in a intellectual situation to actually decide whether the consent is the right thing or not, etc. So I think this is, this actually brings in two different acts into picture. One is the National Digital Health Act, and then there is a DPDP. So very interesting question, Pawan. Over to you.
Well, if you are a hospital, then you are an absolute fertile covered entity under the DPDP Act. Why? Because they're ultimately dealing with personal data of your patients, of their medical data. So one is for adult patients, you still have to give notice to these adult patients at the time they come in, take their consent, and then only go ahead and process the data. That's one. Number two, if you are getting children as patients, then a child is a minor. Anybody below the age of 18 years is not an adult. And therefore, if you're a child, you do not have the intrinsic legal capacity to go ahead and give a consent. In that case, the consent will have to be given by the natural guardian, the father or the mother, whosoever is going to be applicable. So before you admit the child patient into your hospital, please go ahead and get the consent from the guardian who's coming, natural guardian, the father or the mother. And after only have you taken consent, please only go ahead and process, which means does it actually mean that you will also only do admission of the patient after you get the consent? The answer is a clear yes. So I'm reminded by the famous scene in the Hindi film Munna Bhai MBBS, where they say that before we can admit you, you'll have to fill the form. Unfortunately, this law is saying, please, before we can admit you, you will have to first get your consent, first give notice. So imagine a child is coming wounded and he's crying for attention. The law is now saying, hold on, you don't treat him first. First, give a notice to his guardians, maybe a printed form. Get their consent. Only then will you be able to get his data onto your computer systems. That will tantamount to processing. That will be tantamounting to collecting. And then only you can actually start this entire process of giving treatment. So very, very complicated. But again, some people may look much more bigger, but maybe below 18 years. We can actually see puberty is coming in much earlier. So how do you actually look at a patient and say whether he's minor or not? And you think he's a major, and you start taking his consent as a major, and you realize he's below the age of 18 years, you're going to be in a huge problem. So therefore, there are additional compliances that you as a hospital would be required to do to ascertain the age of the entity as below 18 years, and then taking appropriate steps under the DPDP Act. In a nutshell, life is going to get far more complicated as we go forward. Thanks.
Okay, I saw that, Vishal Seclor wanted to add to this answer. So who's going to answer this? Is it you, Devesh? Yes.
Yeah, so I can quickly comment on this. See, the security, privacy, and responsiveness seem to be in conflict in some of these cases, right? That hey, if I want to secure, I cannot make your data private, and if both have to be done, then I cannot respond on time. In this case, to a wounded child, which is not a good idea, and so on. So without getting into the details of this particular situation, what data-centric security technologies like Seclor do is that they separate the data from its control. So you can collect the data, but still relinquish control of that data, or the other way around. You can control the data without really having the data with you. So for example, one scenario in the case of a emergency minor, having an emergency treatment requirement would be to collect the data, but not to gain control of that data till the time the formal consent process has been completed. So then you are collecting the data, you have enough, right? Maybe the medical history of the child and so on. But at the same time, you have the capability to relinquish that control at any point of time and say, hey, all copies of that data will vanish if I don't get the consent within a specific period of time, right? And so on. Okay. So that would be a scenario to match these two competing objectives.
So Vishal, there are 3 pointed questions for you here. Okay. One question from Shyam Gopal here is, may I know how Seclor can help in achieving DPDP compliance, I would assume?
Yeah. I'll do the 30-second version, and then we'll reach out back to you. So I think the fundamental premise of the technology that Seclor has is we have created a technology which allows security and privacy controls to be built into data itself. So now a piece of data, it could be an email or a document or an X-ray scan or what have you, by itself knows what is the security and privacy policy that meaning the document, needs to follow. So for example, you can plug in rules like only a specific set of people can access it for a certain period of time, and after that the document effectively self-destructs, very akin, even though the DPDP doesn't provide for the right to forget, right? There are other reasons why enterprises want to make sure that they have the capability to defensively destruct the data and so on. So we help enterprises in making sure that these controls are built into the data itself, so that this whole chase of, hey, the data is on the device, so I need to secure the device, it's on the cloud, so I need to go secure the cloud, it's traveling on the network and so on, all of those can go away if privacy is built into data itself. And that in essence is what Seclor helps enterprises, right? But
excellent.
Yeah.
Excellent. One very technical question for you, I guess, for you, Vishal. What is JNDI connection pooling? Is it necessary to do JNDI connection pooling?
Okay, this is beyond my technical depth, I have to say. So we will have to, or at least I will have to come back and seek help myself before I answer the question. We'll come back on email.
Okay, I have a few more questions. I think one is for, I think Pawan and Vishal, you can add a bit from your experience with Seclor. Is it true that startups will not be required to comply with all compliance requirements of DPDP? How can a law have a differential treatment? I think this is assuming that the startup doesn't have to comply with DPDP. Pawan, I think first I'll pass this question on to you.
Well, there are certain provisions of the DPDP Act which can actually empower the government to go ahead and exempt certain startups. But to expect all startups to be exempted is going to be a erroneous presumptions to get started. Why? Because this is even applicable to the government and governmental entity. So there's nothing special only with startups that they need to be exempted. Yes, the government has been given the discretion to exempt, and the government may exercise the discretion under certain given circumstances. But the thumb rule is almost all startups must, as a part of good practice and good cyber hygiene, ensure compliance with the DPDP Act. Thanks. Over to you.
So there is no exception, frankly, is what you're saying.
Well, there is a provision under which the exemptions can be given, but please let's understand that only the law has been gazetted. It's not yet even come into effect. The government under Section 1 of the DPDP Act says that we will implement different sections or different provisions of this law at different points of time. So the government is right now in the process of making rules and regulations. So it's very early to celebrate right now, to say that all the startups are out. Let's wait for these rules.
Pawan, my question is, isn't this already an act passed by Parliament?
It is a law passed by Parliament. It's become the law of the land. But Section 1 says that the government will have the power to go ahead and implement different portions or different sections of the law at different periods of the time. Right now, the government has not specified which section is going to be applicable when. And the logical explanation behind the same is that the government is working on rules and regulations under the DPDP Act. They are in the process of appointing the DPDP board or the Data Protection Board. Once these two things are put in place, then I expect a lot of these provisions to be implemented. At that point of time, we will see what kind of exemptions can be given to startups.
In that case, today, if I am breached, and I'm a company, I'm breached and I don't report it in 6 hours, I'm still not liable because they still have not implemented the law in its fullest form.
Not at all. No, you are completely not correct for the very simple reason, Vaidi. You are now governed by the IT Directions 2022, which are applicable since 28th of June 2022. You don't comply, no problem. You will automatically commit an offense after 6 years, after 6 hours of you're coming to know of the incident. However, in India, every man steals. The man who gets caught becomes a thief. The government has the next 7 years to go after you and to prosecute you. And you can ride on your luck to say you don't get prosecuted. But if you tend to get prosecuted, it's going to be a very, very tough kind of a situation. So let's not celebrate to say, look, I'm exempted. So, law does not exempt any categories from basic compliances of all laws. So it's in any case prudent. It's good to show the exercise of due diligence when I show that I'm complying with applicable law. Thanks.
So this probably answers Ajit Joel Peter's question, whether B2B manufacturing sector falls under DPDA. My answer would be, hopefully I would think that there is no sector which is exempted. So B2B manufacturing sector would also fall. That's what I would assume.
Absolutely.
Okay. Any observations on the startup part, Vishal? Because you had been a startup once, now you're beyond that.
Yeah, no, nothing material to add, except that by default, everybody is in this net unless you have specific exceptions, right? So, and at least I don't know of any company which has been able to get this exception in the last couple of months. So yes, everybody is in this net, including manufacturing and hospitals and startups and not so startups.
Okay, got it. This is a common question which has been going on, Pawan. You and I have discussed it many times. Vishal would agree with it. The question here is from an anonymous person. In case I'm interested in the work of storing and processing data with a vendor who takes care of end-to-end in the cloud, both CapEx and OpEx, and any breach happens, who is really responsible in this case, right? Of course, you can't outsource your liability is what we know, whether the organization or the entrusted vendor. I know the answer, but I'll leave it to Pawan.
Thank you. I think it's very clear. As an organization, you continue to be liable. Your vendor at best is only an agent to you being the principal. And it's your responsibility to ensure compliance, because ultimately, who has to go to jail? Your vendor doesn't go to jail, you go to jail. Who pays up 250 crore rupees? Your vendor doesn't pay up, you pay. So ultimately, the stakes are for you. Therefore, you have to take adequate steps to ensure that whosoever vendor that you are actually outsourcing your work to is ensuring compliance with the IT Act, with the DPDP Act and the IT Directions 2022. And also you have to take a very proactive stand, because your seat is on fire. You don't exercise due diligence. You don't supervise the implementation of this law in vis-a-vis data that's being handled or processed by a company. You're going to be in trouble. And I just want to pause here. The way that in Section 2 of this law, the DPDP Act, they've defined processing. It also includes collecting. So the moment I start collecting, the law presumes that this is part of processing. And once that happens, I think you are going to be equally liable. So you'll have to take appropriate steps, indemnities. Your vendor can indemnify you from a civil standpoint, but there's no criminal indemnification. You alone will have to go to jail. So please ensure that get your documented compliances so that you don't land up going to jail, or you don't land up getting fined up to 250 crore rupees. Because even if you say that, sir, in my balance sheet, I don't have 250 crore rupees, the government will say, no problem. These 250 crore rupees will be considered as areas of land revenue. And therefore, these can actually be, at any point of time, be collected from you by disposing of your properties, attaching them, selling them, stuff like that. Thanks.
And the only thing that I have to add over here is that, of course, it is important to comply. But in this case, right, where some part of the business is being run by a third-party vendor, it is equally, if not more important, to prove that you complied, right? Which means that the vendor's access to data and systems and applications and so on has to be logged and recorded by the company, and that responsibility, which is the responsibility of proving compliance, is still very much with the principal and not the agent.
Okay, I will take two more questions. Vishal, there is one straight question for you. Your current Seclor customer is asking this question, name not given.
Okay.
You are currently using Seclor. Whether are you compliant with DPDP or any standard sets on data encryption? Is the question to Seclor.
I'll interpret the question two different ways. So, is Seclor itself as a company DPDP compliant? We are working our way towards it. Right? We ourselves, just like many other companies, are interpreting or trying to make sure we interpret it right. So today I cannot say that we are compliant, but we'll get there soon. The second question is whether our products and services that we supply, are they compliant to DPDP? And over there, DPDP doesn't introduce compliance for systems. I mean, this compliance is for data and so on. So we've helped a lot of enterprises. We have active engagements even now where we are helping enterprises with compliance to regulations using our expertise and tech.
Great. Two questions which are related. Probably, Devesh, if you are telling me it's the last time I'll do that. This is an interesting question because we are touching on insurance, which we never touched on, Pawan. The question here is from Amol Desai. What action should a data fiduciary take in case of data deletion request from a principal, though there is another data retention mandate from another regulatory, example IRDAI, to keep it for certain minimum age? I think it's 7 years or something like that, right? If I remember right. So, you have certain conflicting demands. What do you do?
Well, you will have to first look at which law is applicable to you. You have to be mindful of the fact that once this data principal asks you to delete the data, under the DPDP Act, you are mandated to do so. But you have to understand that the DPDP Act is not a special law. It's a supplemental law to existing laws, the special law being the Information Technology Act 2000. Under the IT Act, specifically, you are asked to retain electronic information for a particular period of time. Under the said requirement, different regulators have come up with their own vertical specific requirements. So you are definitely going to be governed by that. So you can vis-a-vis the customer or data principal show that I have deleted, but at the back end, you will still have to retain the data, because the primary mother legislation, being the Information Technology Act 2000, which is a special law, is actually going to be asking you to go ahead and retain the data. And this DPDP Act says it's only in the event that there's a conflict between my provisions and other laws, my provisions will apply. But it still does not have the non-obstante clause like it's there under Section 81 of the IT Act, which says, notwithstanding anything inconsistent therewith contained in any other law for the time being enforced, the provision of the IT Act will apply. Now, since that language is not there, I think you will have to have the twin approach. You could delete the data for the purposes of your data principal customer, but please retain it for the purposes of the mother legislation, being the IT Act or your sector-specific regulator notification, which is also going to be applicable for you at the same time.
So,
Thanks.
Pawan, how does a company both delete and retain data? Aren't these opposites of each other? Like, what does it even mean?
There's a huge conflict. Even in the existing provisions under the DPDP Act and the IT Act, I see huge conflict. And it'll be up to the judiciary to come up with a harmonious construction or a harmonious interpretation of both these conflicting provisions. Because what it effectively says is that vis-a-vis the front end of the customer, you'll have to delete it. But because you are ultimately an intermediary, you would be governed to ensure retention. You will also have to retain. So, but at one point of time, you will have to stand clear and tell your customer, sir, you're a data principal, I'm deleting it, but I'm also be required to comply with my other statutory obligations under special laws, and leave it at that. If he tomorrow wants to sue you, we'll have to look at it. But this matter will have to be adjudicated more by courts, because right now it's a huge confusion. Thanks.
Yes.
And one question here, I know the answer, but how important it is for banks to implement it? This is Miravali Sheikh.
As important as it is for you to remain out of prison, right? Is
I know.
Quick answer. I mean, people can figure out where does that fall in their priority hierarchy of needs and so on.
Yeah.
But Pawan, I'm sorry, I spoke over you. Please.
No. I was just saying, banks are like the crown jewels. They have to mandatorily comply. There's no choices, because they're dealing with sensitive personal data, which is definitely part of personal data, being financial data. You have to mandatorily comply, and you have to get your proofs in place, because this is going to open up a new tsunami of litigation. What's going to happen is people are going to complain against you left, right, and center, knowing fully well that they will not get a single penny from you. But the sadistic pleasure of having your company to shell out 250 crore rupees to the government is a great pleasure that's going to motivate large number of either competition or other players. So it's even more better that be prepared. You know, the fire is coming and hitting your fortress. I'm only saying, please put your fire suit on, so that as and when the fire comes, the fire does not go ahead and harm you. And that fire suit, which is in the form of your compliances, they are the ones that they come to your rescue. Thanks.
So I'm looking at it from a completely different point of view, having come from a ransomware management background and a cyber response background. Now, the ransomware experts, these guys will find a new way. Normally, they exfiltrate and tell you that I will sell your data. Now I can say that, look, I've taken your data. Now the data is public, and, you either shell out 250 crores or go to prison, or at least pay me 100 crores, right? And I will give the data back to you. So this is going to be a completely new business model. Is for the ransomware as a service kind of people, who are malefic people who are loitering around looking at new avenues of revenue. So how prepared the customer is on cyber responses, on using products and services like Seclor and Raksha Technologies and the legal remedies from your organization, to make sure that they are always on the razor edge, to make sure that, look, as you said, I need to put everything to show that, look, I'm compliant. Now, saying that I'm compliant, I wore a seatbelt, I have 6 airbags, I have NCAP 5 rating, at the same time, God forbid, there is an accident happens, how do you react to that accident and how do you come out unscathed? That's also more important, which means you should always be at the razor edge of technology, processes, and training and skilling the people, making the people aware, because we always say people are the weakest link in the whole thing. How much ever technology you put, it is always the people who can compromise on that. So that's in a nutshell for everybody to look at it. We cannot sit on our laurels. We must have the best of the system, right? Today, I heard one of the organizations, which is a leading security organization, I don't want to name that in public, it is there in public domain, got hacked the 3rd time. Right, that's a security organization, which is a cutting-edge organization in a very niche area of security. They themselves are getting hacked. So we have seen it. We have seen large organizations getting hacked. So nobody is actually safe, but it's not to be scared. That isn't going to take us anywhere. We drive still on the road. We're not scared by accidents. We have to be careful, and we need to be driving properly. So use of the appropriate technologies, use of the appropriate legal remedies, making sure the people are trained. Everybody is a cyber warrior. So make sure that we train everybody to respond to the situation, fire drill kind of things conducted all the time. That's important. Vishal, your closing comments.
Thank you, Vedi, and thanks a lot, Pawan, for taking time out on behalf of all the attendees. My last comment on this is that as enterprises are looking to chase data, right? This is finally going to become a data chase, right? Because data is collected from third parties, then it comes into the enterprise, it hits 20 different systems within the enterprise, it might go to another set of third parties and so on. From the enterprise perspective, chasing this data around from the time it was created to the time all copies are deleted is a very difficult endeavor. And following all these systems and people who touch this data in any meaningful way is a challenging task for enterprises. And there's no real option except to make sure that the whole infrastructure and posture of security and privacy becomes centric towards data itself, right? So that's where I wanted to end this conversation. But Pawan, any last thoughts, words of wisdom?
Well, I can just say, thank you. I can just say, the law is expecting all of us to become superhuman beings. But the fact is, we are not superhuman beings. Therefore, it's imperative that you must take appropriate support. Take support of appropriate tools, the requisite industry vendors, so that they can take some part of your burden away. Also, vis-a-vis your documentation, your policies, get external help so that at least you are covering the parameters right. And finally, we'll have to adopt a culture of resilience. We'll have to be mindful of the fact that we will be attacked all the time. And the law is always going to be in question. It has to be at the back of our minds. And more stakeholders would be inclined to use the law against us. Therefore, be in a state of readiness. Get your documentation, get your evidentiary proof in place to show that you're compliant. And then please go ahead into this particular race. Once we are into the river, there's no need for us to be afraid of getting wet. We are part of the ecosystem. But just get your fire suits up, get your good protections in, and I think it's a good jolly ride as we go forward. Thanks.
Thank you.
Thank you. Thank you, Vishal. Thank you, Pawan, for this, and thanks for all the participants. We know that there are a few questions which we could not get to, but we are going to respond by email to those questions which we could not get to. I want to assure you that you will have the responses from the team here, from the panelists here, and appreciate each one of you taking your time off and joining. And Vishal, thank you for joining.
Thank you.
At the unearthly hours from California, we really appreciate that.
Jet lag helps.
And thank you, Pawan, for sharing the wisdom. Seclor and Raksha Technologies, we are delighted to be bringing these, and we'll bring more seminars to you, more value adds to you. Thank you, everyone, and have the rest of the day. Very good day. Thank you.
Thank you. Thanks a lot, everyone. Thank you.